Thank you very, very much for investing your evening by spending some time with colleagues here at Bowmans. We do appreciate your attending tonight. I'm David Jarrell. I'm a partner at Bowmans. I'm a financial services regulatory lawyer. That's my day job. And I was thinking, I've been here since like, I don't know, 1995 or so. It's not funny. That wasn't the joke. The joke's coming. And then I would not be able to say, hello, I'm David, I'm a human rights lawyer. But in a way, I kind of can now, which is very exciting because it just shows how things have moved, but also how sort of entering into practice with a clear idea of what practice is going to entail also shifts quite significantly. So I'm pleased to have this gathering. I'm very grateful to the Centre for Applied Legal Studies, CALS at WITS, for their collaboration with Bowmans in order to raise awareness around the issue of business and human rights. This is a follow-on for some of you may know, all of you may know, from a presentation that was held in September. And we hope that those of you who've returned have returned because you're sort of ignited with passion and feel that this is the right place to express that. And in that context, or on that point, I just wanted to encourage frank debate, because I think this shouldn't be, or doesn't seem to be, controversial space. But of course, the minute you wade into conversations about business and human rights, or any sort of sense of social and ethical principles within a legal environment, you do have to start weighing up against traditional principles and ways of being and ways of doing that are threatened by progress. And I do believe this is progress, as our panelists will tell you about later. I mean, concepts of business and human rights have come a long way since early instruments like the Sullivan Code, and then developing through the 80s and 90s with things like the UN Principles for Responsible Investment, all really principles-based instruments. And I think it's fair to say that Europe has led the way in maybe realizing, but certainly doing something about the fact that simply having principles doesn't necessarily, it can, but doesn't necessarily carry enough weight in adjusting corporate behavior. And there are reasons for that, and they're structural reasons, and therefore one often needs structural solutions. So I was very interested to see the release of the EU Directive on Corporate Social Responsibility and Due Diligence. Sorry, corporate, man, I got it wrong. Anyway, that one. We'll hear more about it from the experts in a moment. The CS3D, the CS3D3, yeah. Thank you. That's what the experts are over there. And obviously what we've been looking at for some time, sort of horizon gazing in a sense, is what does this mean for South African companies in principle? African operations generally, we are predominantly parts of European, British, and American, but that's less relevant in this context, supply chains. I don't think South African businesses have quite got to grips with the potential impacts that sort of supply chain due diligence could have on them. Although I think we do have the benefit of starting from a relatively heightened appreciation of issues around environmental, social, and governance considerations, and what that means in real terms in a country like South Africa, when we talk about just transition and concepts of that nature. I trained last year. I was invited by BATSETA, which is the Council for Retirement Funds, which seems a little bit remote from this presentation, but trained them on their re-release or an update of the Responsible Investment and Ownership Guide. And I have the pleasure of serving on the technical committee for one of BATSETA's subordinate structures, which is the Asset Owners Forum of South Africa. Now, the Asset Owners Forum has something like 4 trillion rand that it, being a group of the 16 largest pension funds in South Africa, want to direct, A, to infrastructure, but B, to impact investment more generally. So impact investment with a particular focus on social infrastructure and then also with a focus on other projects that come along. So we're not wanting for money, but what was quite clear is the lack of translation into intent, from intent into activity. And the reason pension funds sort of resonate in this space, besides the fact that that's my day job, is Regulation 28 has for a very long time, the Regulation 28 to the Pension Funds Act, has established that it is the duty of boards of pension funds, which actually manage more money than banks in this country. And that's true in every other jurisdiction in Africa, by the way. That's where the money's lying, and that's where the money is waiting to be deployed in a responsible way. But of course, we've heard this argument, we've heard the story that there's a handbrake on these kinds of investments because people feel, can you subordinate fiduciary duty or getting the best returns to feel good investments? So a forum of people who are interested and read in and learned and who attend things on Wednesday evenings to get to grips with this better is very, very important. So I would encourage you to engage very frankly and openly with the experts you're going to meet shortly, because they will hopefully help you and us to get those conversations into some sort of real traction. I shall hand over to Anda Dungula from the Center for Applied Legal Studies, who will be effectively your host for the evening, and she will in due course introduce you to your panelists on the evening. But thank you for coming. I hope you enjoy your time here.
Good evening, everyone, and welcome to our event this evening. My name is Anda Dungulu, and I am a candidate legal practitioner at the Center for Applied Legal Studies, which we refer to in short as CALS. Well, firstly, I want to welcome you again. Welcome. I will be your facilitator for this evening, and I hope we will have a robust and really interesting discussion on our topic for the night. Now, firstly, I'd like to introduce just briefly who we are as CALS. Now, CALS is a public interest law clinic and a human rights organization. We are located in the Wits School of Law at Wits University, and we were established in 1978, so about 46 years ago. Our organization is older than some of you in this room. When CALS was founded, right, the aim was to just ensure that there was better access to justice. And remember, this was around the time of apartheid, so it was an important space for activists at the time to have, right? And, we have, as an organization, continued to, promote human rights and, ensure that we hold corporations accountable, as well as just in general systems of oppression in South Africa and beyond. Now, our vision as an organization is to ensure that there's, historical as well as social justice, that should be achieved. And our work, our vision is to ensure that those are achieved. But more than that, we want to also ensure that, states institutions function better and are better capacitated, and just powerful entities are able to be held accountable, by those pushed to the margins as a result of their actions. Now, the Business and Human Rights Program at CALS, right, pursues this vision by, working towards ensuring that corporations, respect human rights primarily, but also are held accountable for violations. Now, you may be, wondering, how, all this has come about, right? The business and human rights space is fairly new, firstly, and it's not just fairly new, but it's a fast-growing area of law. And Carl's, in partnership with the pro bono department here at Bowmans, we partnered up to sort of bring an understanding, right, to the business and human rights space overall. We understand that corporations for a very long time, in fact, have been, have had a reputation and have been known to actually impact human rights, in communities that they operate in. And so we have partnered to ensure that, we have this space where, as legal practitioners, with the understanding that, business and human rights as a discipline it goes beyond, it goes towards all forms of legal practice. These includes your employment law, your competition law, your environmental law, right? Business and human rights is always in the middle of, all these legal forums. And so we would like to create, in fact, we have created this seminar series and we are, co-hosting it as a way to sort of bring human rights issues as well as, corporates into the same space where we find an understanding, but beyond that understanding, we are able to, as legal practitioners and lawyers in South Africa, we're able to find ways legally that will ensure greater protection of rights, as well as greater protection of the environment by corporations. Now, moving to what brought us here today. Last year in October, Carls and Bowmans held our first seminar in this series. And in that seminar, we were exploring in general, just the business and human rights, in context, right? From a historic lens, as well as from a political lens. We also looked at the development of the law in this regard, as well as, what are the realistic, what's the realistic value in this space, for those who are affected by the actions of corporations. And that is what we are going to explore this evening, having our second seminar in this series. Now, the second seminar in this series will focus on a topic actually that is very important, that's very interesting, and actually our seminar comes at a point where this topic has just become really, known in the space and has become quite the topic of discussion. And this topic is a corporate human rights due diligence process. This evening, we will be exploring what that is, as well as what it means for South African lawyers. We'll start by hearing about developments in human rights due diligence laws across Europe and the global north, and most recently within the European Union. So as I mentioned, there have been quite interesting developments in this area recently, but it has happened, in the global north, in Europe, and particularly by the European Union, who have passed a new diligence directive in their processes. Now, this context will enable us it will enable our panel to explore such due diligence processes, what they mean for South African lawyers, and just in general, what they mean even for marginalized communities, as well as, law firms, as in-house counsel in corporations, as to how to engage and even, encourage human rights in spaces when advising regulators, when advising companies, and even when engaging with affected communities. So to help us explore this topic more broadly, We have a wonderful, wonderful panelist, a wonderful, group of people who are experts in their fields of expertise, and they will be taking us through our topic of discussion for the night. So please welcome them with a very nice round of applause. I will introduce each speaker fully before they go through their presentations. But in summary, we have Inga Carey from the German Institute for International and Security Affairs, who's joining us virtually from Berlin in Germany. We also have Wandisile Mandlana from Bowmans. We have Sikolu Tango from the Rosa Luxemburg Stiff Tank. You will pronounce it for me properly. We then have Ariella Scher from CALS. So before we begin our discussion, I just want to highlight to the speakers that they have about 7 minutes each to present, and once the final speaker has presented, we will then open the discussion to the floor for your comments, for your thoughts, and your questions to the speakers. So to kickstart the evening for us, Inga Carey will provide some context with a background to developments across the global north in respect of corporate due diligence processes. Inga is a research associate at the German Institute for International and Security Affairs based in Berlin, Germany. Her work centers around geopolitical developments, sustainability in global value chains with a focus on critical raw material supply chains. She is a founding member of the research network Sustainable Global Supply Chains, funded by the German Ministry for Economic Cooperation and Development, an international network of researchers working on questions of sustainability in global value chains and formulating policy recommendations for German and European policymakers. At this time, I would like to hand over to Inga to begin our presentation.
Thank you very much. Can you hear me fine? I hope so.
Yes, Inga, we can hear you fine.
Okay, great. Thanks. Well, thank you so much for the invitation. Yeah, my task is to basically outline the EU Corporate Sustainability Due Diligence Directive. Very long name. That's why everyone is just calling it CS3D or CS-DDD now, because we can't remember what it all stands for. So just a disclaimer, I come from a background of political science. I don't have any legal training. So I'm looking at these processes also from the lens of a political scientist. But of course, I have to get into the nitty-gritty of what these directives actually say and how they apply as well. So this is what I'm going to try to do now. If you could go to the first slide. Now, I have to admit, I did not create this meme myself. I stole it, but I think it quite well symbolizes how many of us feel right now. There is a plethora of different global corporate sustainability regulations having been developed over the past, well, basically 10 years. I don't know if you know, the EU already has a number of sector-specific regulations, such as the timber regulation, the conflict minerals regulation. And now a new one new ones were developed as well, the Corporate Sustainability Reporting Directive. So we have, on the EU level, we have already some regulations. We also have regulations, national legislations in France, in Germany, Great Britain, but also beyond the EU. So in Canada, there's a arguably more limited Supply Chain Act in Australia as well. And beyond those national and EU initiatives, we also have initiatives on the international level. So, of course, the UN Guiding Principles and the UN Binding Treaty process. And to top that, we also have voluntary sustainability standards, multi-stakeholder initiatives, industry scheme, etc. So there's like this plethora of different regulations, initiatives. Some are mandatory, some are voluntary. And just to give you a quick overview on the genesis of the CS3D. So after notably the French law, the French Supply Chain Act was the first one within the European Union to be adopted on a national level. Then Germany followed with the Supply Chain Act. But there were also moves on the European level. The EU Parliament, they requested the Commission to draft such a directive. So the Commission published, well, actually the Commission's draft directive was delayed multiple times because the scrutiny board said there was insufficient impact assessment. But when the draft was finally submitted, it went through the regular EU legislative process, which is, of course, the trilogue. So you have the Commission, the Council, and the Parliament going into negotiations and basically figuring out a version of the directive that all can agree on. And this was done. The trilogue parties made a decision. The Parliament, the EU Parliament voted on it. Well, but then, and I have to say, very much due to fault of my own government, the decision was opened up again because Germany had issued criticism and a passing majority in the council was actually not secure anymore. So a new compromise had to be reached. So that is why when you go to the next slide, I'm going to be talking about two different versions of the CS3D. You see on the left side, there's the CS3D trilogue. So this was the initial version that had been adopted by the Parliament, Council, and Commission. And then there's this CS3D compromise, which is basically the revised version, and it is the version that we're now working with. So this is the final version of the directive. And then because I was also asked to shed a little bit of light onto national legislation, I am also comparing it to the German Supply Chain Act, which is on the right side. Right, so in terms of scope, the trilogue version, so the first version, it basically covered around 1% of companies located within the EU. It had two variables. The first one being the number of employees that a company has, and the second one being the net global turnover. So these were the two criteria by which the scope of this directive was defined. But then it also had high-risk sectors, mining, textiles, agriculture, construction sector, where these thresholds that had specific thresholds that were lower. As you can see here, it would have applied to companies already with 250 employees and a lower net turnover. In the revised version, that was actually one of the biggest points of contention. So the revised version notably set the threshold higher or lower. Which one is it? Well, it set the threshold to basically apply only to half of the companies that were originally envisioned. So about it is estimated for 5,400 EU companies will now be affected. And even though it does also affect to non-EU companies operating within the EU, there's no employee threshold for these non-EU companies. And also another thing that was a significant change is that high-risk sectors were eliminated. If you compare that just quickly to the German Supply Chain Act, there's no turnover threshold. The threshold is simply based on a number of employees. So another very contentious point was the inclusion or exclusion of the financial sector. In the first version, the CS3D foresaw that the financial sector be temporarily exempt, but be included in the directive at a later stage. Now, in the final version, the financial sector is largely excluded, and there is no immediate perspective of including the financial sector. Where it is concluded is in the German Supply Chain Act. And now this is interesting because the EU CS3D basically established a ground level, a basic level of, okay, every EU member state has to comply with this. But then every member state can also implement their own individual national stronger legislation. So you could say that because in the German Supply Chain Act, the financial sector is included, that might mean that, you know, it basically German financial companies or financial institutions, they are also covered under the National Supply Chain Act. But from a political viewpoint, it would not surprise me if after the EU law comes into effect, there is another political debate within Germany that says, in the sake of a level playing field, we would like to adapt our national law to the standards upheld by the European EU level law. Now, in terms of applicability, the trilogue version foresaw a risk-based approach, but across the entire value chain, so upstream and downstream. The compromise, in terms of wording, it was changed from value chain to chain of activities. And it's still a risk-based approach, also across the entire upstream value chain, but with only a limited downstream value chain. It includes distribution, transport, and storage, but it does not go further than that. It doesn't include recycling, disposal, or waste management. And with the German SCA, it only covers upstream suppliers. If you go to the next slide, please. In terms of climate and environmental provisions, in the German SCA, there was very, very limited environmental due diligence foreseen. It had limited applicability to existing environmental conventions, mostly on chemicals. In the compromise, so the final version, it still foresees that companies have to report on climate transition plans in line with the 2015 Paris Agreement, and they have to implement it. But what was new is that they excluded that the implementation of these climate transition plans is connected financially to directors' duties. So initially, it was planned that the implementation would be driven by financial incentives for company leadership, and this is no longer the case. In terms of civil liability, the CS3D does include civil liability in contrast to the German Supply Chain Act. But it has been restricted to liability only in the event of intentional or negligent breach of obligations, and it does not apply to business partners, so neither direct nor indirect. The burden of proof stays with the plaintiff. However, the latest version of CS3D does foresee evidence disclosure, which basically means that courts can order the production of documents documents produced by the company that would aid the case. Now, in terms of penalties, the member states are responsible to establish national agencies to monitor the implementation of CS3D. And this raises the question of, is it going to be evenly implemented in all member states? We can see this with previous regulations, such as the timber regulation, also the conflict minerals regulation, that because it is up to the individual member states to monitor and implement these directives, we do see significant differences in the level of implementation and enforcement across the member states. So this will be something to monitor in the future. The approach of the penalty is basically twofold. The first one is naming and shaming. So it is foreseen that companies that are not aligned with or that are in breach of the directive will be named publicly. And there's also a financial penalty of around 5% of net turnover. And in the German law, it also includes 3 years exclusion from public tenders. Now, the implementation normally, when the EU creates a directive, it has to be adopted into national law within 2 years. However, with the final version of the CS3D compromise, and there's been granted a longer transition period of 5 years, although you have a cascade of after 3 years, it's already applicable to companies with more than 5,000 employees. After 4 years, more than 4,000 employees, and after the 5 years transition period, you have the 1,000 employees. Now, if you go to the next slide, I'm not going to go into actually evaluating the CS3D, because I think that the other panelists will raise some criticisms. I'm just going to point to some future research questions that we should be looking at. The first one is the big question: will CS3D actually improve long-term sustainability along GVCs, or will it just be a box-ticking exercise? We have anecdotal evidence that due diligence in companies is slightly shifting from a strategic approach to a compliance-based approach, so that companies that implemented due diligence before it was mandatory are now asking, well, what is the advantage of going beyond those legal requirements? Our main concern right now is just compliance with the legal obligations of CS3D. And that's obviously not really what we want. Then the big question is also, will it lead to cut and run? So companies going out of sensitive contexts because they fear of consequences, they fear of not being able to comply with CS3D. And again, that is not what we want. That is not what the directive intends to do. But that will be something that needs to be monitored. And then the big question is implementation in producing countries. So in my view, the discussion is very much focused on how the law will affect competitiveness and how it will create bureaucratic burdens for European companies. So a lot of these companies actually make this argument of cut and run to as an argument against the directive. But I think we need to reiterate over and over again that the primary focus of this legislation is not to exclude suppliers or even entire countries that might not be compliant with our European standard, but the goal should be to support and enable these suppliers in their capacity to build capacity to lift standards and employ more sustainability along the value chain. So that means that companies must engage with their suppliers in capacity building. That is a really, really important point. And the last two questions will, of course, be what is the role of multi-stakeholder initiatives and industry schemes? So how well can they be incorporated into this smart mix of mandatory and voluntary requirements? But how do we basically prevent that individual companies rely on these industry schemes or certification schemes and don't do their own individual corporate due diligence? And then last question, how will this directive interact with other European legislation? As I said, there are already sector-specific legislations in place. There's the new deforestation-free supply chains, the conflict minerals, the new critical minerals, the battery regulation. And then, of course, on the international level, I believe that Sika will be touching upon later, the binding treaty. How will that interact? And the big question that is always asked, will this have a Brussels effect beyond the EU, so that other countries, other states in the world will also develop their own due diligence directives or laws, legislations. All right, that is it from me. Thank you very much. And I look forward to the discussion.
Thank you. Thank you so much, Inga, for that introduction. I thought it was very important to let you go beyond your 7 minutes, because we need to properly understand this directive.
Sorry,
so we
I
can
tried.
follow
I tried.
the rest. It's okay. So we can follow the rest of the conversation, right? And thank you so much for that. Our second speaker for the night, I know he probably cringes when I call him by name, because in Xhosa, we're not allowed to call, people who are older than us by our names, but please welcome Wandisile Mandlana, who will bring us back home to South Africa. He will take us through the impact of this due diligence, or rather such a due diligence, on South Africa, on South African-based supply chains, and will explore the practical measures that will ensure this alignment. Wandisile is a partner here at Bowmans. He has 20 years of practical experience in public law and public procurement. He advises both the public and the private sector clients on the application and interpretation of various regulatory laws. His expertise extends to administrative law, constitutional law, business and human rights, and mining law, including the intersection with environmental law. Wandisile regularly advises on power and authority of government actions or public entities, restructuring of state-owned enterprises, granting of rights to use of state assets, public-private partnerships, developing legal frameworks, and assisting clients to procure licenses and defend regulatory actions relating to those licenses. Prior to joining Bowmans, he was actually a lecturer at Rhodes University in the Eastern Cape. Please welcome Wandisile.
As you're reading that, I kind of wrote it. I don't recognize half of things that I'm playing that. Oh. There again, exposing what Anna is talking about, my age, forgetting the most important thing, to switch on the mic. Thank you for that introduction. So what I was hoping to do in this 7 minutes, which is, as you say, it was important for for Inga to speak a little bit longer. Now I shall no longer waste anyone's time trying to go back to the CSDD. But as David also in his own remark, and I'm happy to see Obab Matuna, who have been in this human rights space for longer than some of us, when we say human rights and human business and human rights is not a new thing. It's always been there. But it from time to time keep on re-emerging because of certain factors that drive it. So one of the instruments that are used to give effect to human rights are corporate due diligences. And we have seen a number of instruments coming into play in the last little while. So what I'm sort of going to be doing, just deal with 3 things. Briefly mention what some of those, in addition to the ones of European origin, as Inga was discussing, and what drives them, why are we getting them, or why are they being developed, and then focus into South Africa as to what is the impact of these laws in South Africa, and how naturally one can meet the requirements or mitigate the unintended consequences, if any. So starting again, as one would then say, looking at the development in the due diligence space or corporate due diligence space, in addition to CSDD, there are other instruments that are emerging, and some of them are quite old. You've got your OECD guideline for multinationals on responsible conduct, which really is talking to one of the points Inga was talking about just shortly on competitiveness of EU companies, that a consideration by some is given to cut and run. And as you would know, with multinationals, is they exist across jurisdictions and geographies. And what often happens is the most horrific human rights abuses in some instances or adverse environmental impacts occur in one jurisdiction and they go to another jurisdiction to exist in those spaces. So the emergence of these instruments is actually trying to drive or stop such a, I think I trust my voice. Can I project, or is this not interfering? Okay. Yeah. So there is those sort of instruments, the OECD guidelines, which have been recently reviewed. I think the latest review was in 2023, which shows the extent of which there is a rethink on these due diligence questions. And one of the interesting emerging topics here has been, as I think 2-3 weeks ago, UN Secretary General announced a high-level panel that is tasked with developing guidelines to mitigate adverse environmental impacts and human rights abuses in mining of critical minerals. And that panel has just been established recently and is chaired by South African European Commission. And they must respond to the UN or General Assembly before the Assembly sits in September, which for me is not just a rush. It is recognition that we've got these instruments, maybe we must just rethink and reevaluate if they are responding to the present challenges. What is that challenge they are trying to respond to? I think we are all agreed that there is a need and an urgent one to transition to a low carbon economy, to decarbonize our economy. And in doing so, we've got to do that in a just manner. And for that to happen, you cannot have or achieve that objective without really ensuring that businesses impact humans and environment in a mitigated manner. And to achieve that objective of just transition or decarbonization or low carbon economy, whichever other term one uses in this space, whether it's net zero, you unfortunately do need critical minerals. They will propel, they are used in renewable energies and in other green products. Therefore, that's why you're starting to see this sort of upsurge in some parts of the world or in some parts of the globe, an upsurge in abuse of human rights, be it employment or labor rights or environmental rights. Is on one hand, you want to address the climate crisis. And for you to address the climate crisis, you need the very same minerals. And because of the agency with which we must address the climate crisis, you then create these unintended consequences. So that's why then the UN says, we've got all these instruments, then we must look again as to how can we mitigate or what can we do to help companies, because they are inherently, at least the ones I advise, they are inherently committed to achieving greater good. They do know that their products and goods would serve no purpose if there isn't humans or there aren't people to consume those products or to utilize those services. It is in their interest to make sure that whilst impact is done, but it must be mitigated or redressed or remediated. So that is the context in which all of this is happening. As I say, on one hand is the climate crisis question, needing the same minerals to resolve it, but then how do you ensure that you mitigate in a manner that, you introduce tools that ensures that the impacts of business do not adversely or in an unmitigated manner impact on human rights and environment. We are very fortunate then in South Africa that when you look, as I was listening to Inga explaining the CS-DDD and as Flight had the slides, I had the pleasure of reading the slides earlier, so I know what is in them. I'm not teleporting. So you would have seen what she reflected as being the content. And you'd be saying, but this is what we already have in South Africa. And I would agree. That's what you already have in South Africa. Whilst the substance of it is not materially different to what we already have, but there are certain changes or certain impacts anyone operating in the mineral sector would have to pay attention to. So that's what has really changed. It's less about the instrument itself, but it is how it is going to impact a person or a corporation if it does not comply with the relevant requirements or any other instruments that we discuss. In the first instance, why that is important in South Africa is we've got a justiciable human Bill of Rights. In the Bill of Rights itself, you've got a number of rights that are impacted by corporate due diligences. Our labor rights, our environmental rights, all justiciable. And if one is observing throughout the world, there is a rise in consumer awareness or people just being more assertive to their rights. And therefore, we are anticipating that to achieve corporate behavior will change through some of litigation we're going to see in this space. And how it will come about in the most, among other things, Inga is mentioning around the CS-DDD, how the burden of proof still resides with plaintiff, but you may be compelled to disclose information that assists or that establish the breach of the directive. You already know that in the sustainability or in the climate change space, there's a lot of disclosures. And because of those disclosures, you will, if you make any unfounded claim or any unsubstantiated claim regarding your human rights approach or stance or environmental protection, green claims will become an order of the day. That's how we anticipate instruments of this nature will have a bite, justiciability nature of our environmental right, the disclosure that comes with it. And if in the disclosure, there is underhand disclosure or unsubstantiated claim, green claims and human rights abuses are going to be the order of the day. You will see in many of these instruments, some of my co-panelists are going to speak about, they are talking about establishment of grievance procedures. Grievance procedures is anticipating that the consumers are so aware of those products. They are going to take you to task. They're going to complain about your human rights abuses in production or environmental pollution. And then they say you must co-create already a mechanism where you are able to deal with those complaints of human rights at a company level. And that's what is going to create acceptability of your product out in the market. And notwithstanding the fact that these are international instruments, whether regulation or otherwise, as far back as Bowmans drafting the constitution way back then, they thought to have in section 233 recognition of international instruments to be used in informing our law. I'm not even going to go to the status whether they are voluntary or what. Our constitution prescribes that when interpreting the Bill of Rights, which is where you find all these human rights and stuff, you must take into consideration international and foreign law. I'm not talking about the adoption procedures of the treaties, but just an interpretation and use an interpretation that favors the protection of human rights. So what I'm saying is, as I stop, is the old and existing instruments are going to be very potent going forward in achieving human rights protection and environmental protection. Thank you.
Thank you so much for that presentation, Sile, and for making that linkage between the CSDDD and, you know, the South African context. Our third speaker for the evening is Paula N. Novotny, who will explore the potential for due diligence laws to protect vulnerable persons as well as marginalized groups. Paula N. is an environmental, regulatory, and ESG and business and human rights lawyer at Africa's leading full-service law firm, Bowmans Law. Beyond the full scope of environmental, regulatory, and compliance advice, her experience extends to advising clients on ESG, as well as business and human rights related impacts, risks, and opportunities, such as opining on dedicated environmental and climate change related laws, advising in support of project development and strategic M&A activity, conducting human rights due diligence, establishing governance systems and controls and regulatory mapping. She recently also spent 6 months at their alliance firm Linklaters LLP in London on a developmental secondment to their ESG team to learn about ESG developments in the global north. Please, over to you, Paula. Please welcome her.
Thanks. Thanks, and thanks everyone for having me today. I've been asked to speak to some of the practicalities around human rights due diligence, and then specifically in the context of gender issues and challenges. So within the context of this evolving legal landscape and how our obligations are changing, whether based in law or not, the first point that's important to understand from human rights due diligence is when approaching it, it is completely different to a transactional corporate due diligence. A human rights due diligence focuses on risks to people, not risks to the business. And so your entire mind shift has to change in when you approach this risk assessment. Sorry, it's very cold in here, so I might be sniffing and coughing in between. When you are focusing on risks to people, that then means that your stakeholder mapping becomes a crucial part of your HRDD process. From the human rights perspective or BHR perspective, that means mapping out who your rights holders are and who your duty bearers are. Your rights holders are typically your workers, your personnel. It extends to subcontractors. It extends to local communities. It even extends to consumers, as Wandisile has mentioned. And so with each of those subgroups, you need to then understand how the entire range of international human rights might be impacted, not only through your business operations, but your also broader supplier relationships. What does that mean from a gender perspective? That means that when each rights holder grouping is looked at, you then need to pay specific and particular attention to marginalized and vulnerable groups. That terminology is recognized in the UNGPs, our benchmark framework for how to conduct HRDDs. And it recognizes that these subsets or groupings of people face very different challenges, face significant risks, and there are different ways in which you need to respond to those challenges and risks. Gender is one of them. One second. So the UNGPs recognize gender as one of them. So women, children are another, minority communities are another. But as the world changes, we have to acknowledge that those might change too. So the LGBTQIA plus spectrum or community also now needs to be recognized as one of those marginalized or vulnerable groupings. Once you've identified that, it then becomes a very significant contextual project, company, country specific exercise in understanding how gender might play a role in having human rights violations exacerbated or prevented. If you take women, for example, in the workplace, they might not be as susceptible to abuse in a corporate environment as they are on a mine site. And so that operational project-specific context becomes important to your HRDD. The same from an LGBTQI plus perspective and your representation or freedom of expression or your rights to equality. When you as a corporate are looking at whether your bathroom facilities are adequate during your HRDD process, that nuanced vulnerable grouping assessment, looking at your LGBTQI plus community would say maybe you need to have a gender neutral bathroom put in place. If on the other side of it, you're looking at a mining environment where women now do work underground, How do we look at the appropriateness of PPE, so your personal protective equipment, this in the form of clothing? One of the biggest talked about examples of gender sensitive responses to human rights due diligence is this example, in that most mine workers wear overalls when they go underground. For women, they are not as comfortable to use when going to the bathroom as they are for men. So some mines would then change the overall situation where you have a two-piece bottom and a top. Through the grievance mechanisms, some of the female workers had sensitively or anonymously reported that that two-piece overall actually made it easier for them to be raped underground. So they preferred to go back to the one-piece overall. So these are the kinds of issues that you now have to grapple with during your HRDD to contextualize the gender-specific issues, challenges, and risks that are faced within the spectrum of your operating environment and how you need to respond to them, how you need to prevent them. There's also a recognition in the UNGPs that, especially from broader discriminatory tactics, that companies aren't responsible for perpetuating discrimination. So companies aren't responsible that LGBTQI plus is a marginalized grouping. But what these legal obligations now require is that companies mustn't further them and must do what is within their power to prevent them in their own operational footprints, their own supplier relationships, and their own leverageable engagements with others. And I think one final point that I would make then is, outside of these practicalities, you are then in this multinational globalized world that we're living in, faced with challenges, particularly from a multinational company perspective, of operating environments where certain countries have laws that are going to require you to abuse human rights in conflict of your own human rights commitments. Again, taking things like in the LGBTQ space of African countries that don't recognize or are anti-homophobic, or internationals, even in the European frameworks. I think there are some Irish laws that don't recognize same-sex marriages. If you are a company that operates in all of those jurisdictions and you've publicly committed and have a human rights policy that is on your website that says you are not anti-homophobic and you recognize everyone's rights, how do you operate across those spectrums? Sorry, again, all the frameworks that we have provide detailed guidance on how to balance that tension, how to comply with your legal obligations, and also meet your international soft law and new hard law obligations from a human rights perspective. But these are just some of the things that companies are going to have to start grappling with. Thank you.
Thank you so much. Thank you, Paula. Now we have Usiko Lutango to discuss the Global South critique of the Global North's due diligence measures. Siko is a program manager at the Rosa Luxemburg Stiftung Southern Africa office and a minerals governance researcher. Her research focuses on environmental, social, and governance impacts in mineral supply chains. She's also a former German Institute for International and Security Affairs Research Fellow, where she followed the developments around the EU supply chain law. She has also observed the negotiations for a business and human rights treaty to regulate transnational corporations for 6 years. Siko holds a Master of Philosophy in Public Policy from the University of Cape Town. Over to you, Siko.
Thank you so much, Anda, and thank you again for having me. Before I started the presentation, I'd just like to pose the question, actually, why are we here today? Did our parliament enact legislation on due diligence? I think not, right? So then why are we here? So we are here because the EU is about to pass the CSDDD. And the problem with the CSDDD is that it's a unilaterally negotiated instrument within the EU. And however, it has extraterritorial impacts or effects. And this causes a bit of tensions. And I use the third world approaches to international law to critique this approach. So it then brings into questions about who should be regulating global value chains and who actually does it and how do they actually do it. So what the CSDDD will do is that it regulates more than transnational corporations. It will also affect host governments that maybe end up being pressurized by this legislation to enact its own due diligence legislation in light of trying to avoid investment flight in terms of its companies perhaps not complying to a certain standard. So this is despite the fact that it's not negotiated multilaterally, and the fact that hasn't lied with host states as well. So as some of the previous panelists have mentioned, you can locate the CSDD within a number of other laws, the German Supply Chain and the French 2017 Duty of Vigilance Act. And all these laws have been enacted because the UNGPs have kind of become, how can I say, they've become the most widely accepted way of regulating global value chains. And this is in the context where, for example, in the currently negotiated legally binding instrument, you find that there has been a lack of buy-in in the process, especially from global north states that usually are the home states of these transnational corporations. So in light of that international environmental regulatory framework, the CSDD comes up along with other laws, but specifically what they aim to address is disclosure and mostly focusing on disclosure and as due diligence mechanisms, compared to an LBI, which Ariella, a legally binding instrument, which Ariella will go more into detail with, that is a victim-centered instrument that aims to address human rights impacts and also address the issues around access to remedy. So, I mean, as a unilaterally negotiated instrument, coincidentally, you find that some of its biggest weaknesses or pitfalls are actually the most relevant issues for global South states. So, for example, civil liability, we noted that with civil liability, there has to be a direct linkage between due diligence process and the damage. And if that causal link is not established, then there is no case, for example, or liability. So issues also include around private international law, issues around jurisdiction, applicable law, and then also procedural issues, which include issues around burden of proof, access to information, and litigation costs, and also types of remedies that the CSDD offers versus that of a legally binding instrument negotiated at the UN level. So I just want to zoom in more specifically on jurisdiction, on the issue of jurisdiction particularly. So jurisdiction is quite important for the global South states, especially because we sometimes have issues where the state is either unable to regulate human rights violations and provide access to remedy, and also a situation of unableness. So what do I mean by the two? In the case of unwillingness, sometimes you find that some states are complicit in human rights violations, and sometimes are in collusion even with transnational corporations. And this creates a situation where you have patronage-based institutions that do not necessarily take into account the importance of the victim's flight. In that scenario, sometimes you also find a state that is unable to provide access to remedy. And for example, these are the issues around state capacity relating to the resources of the state, and also sometimes issues around a governance gap within the legislation. So within the governance gap situation, I can give you an example. You had an oil spill in Nigeria, in the Niger Delta area. And according to Nigerian law, and I mean, Nigeria is one of those cases where it could be unwilling and unable. So there's an oil spill, and according to Nigerian law, you cannot be held liable for an oil spill that is caused by sabotage. So the victims did go to court in Nigeria and however, didn't win the case. And then they ended up going to the Netherlands and to the UK, and their case was admitted and they won that case. And not only were they, was the Shell as the parent company instructed to compensate, but it was also instructed to rehabilitate the land and the area. So here you see a situation where the court is able in the Netherlands and the UK to take a case that is of a harm that has occurred all the way in Nigeria. So this is usually facilitated by what you call extraterritorial obligations, and is usually governed by provisions of forum non-convenience, where you have to remove it, and forum necessitatis. Also, just a disclaimer, I'm not a lawyer, so Latin is a bit out of my vocab. So compared to the CSDDD, it does not have provisions that govern jurisdiction. So in the case of the EU, what then happens is that the recast Brussels I regulation then takes over. So this is fairly straightforward for those companies that are domiciled in the EU that apply within the scope of the CSDDD. But it's not that straightforward for companies that are not domiciled in the EU, but do apply under the scope based on their turnover. So these companies could be domiciled in third countries. And so when a cross-border case is brought up, what essentially happens in this case is that the national laws of that country, of that member state of the EU, has to take over. And the risk in this is that the member state then, or the member state courts, have to decide whether to take the court to hear the court case or not. So this still leaves a bit of a room where victims are not able to access remedy, particularly in the EU. And I mean, in other jurisdictions and in other cases, there is no law that governs due diligence legislation. So it means the EU sometimes will become probably, you know, at the moment, especially in the absence of a legally binding instrument, basically the place to go, right? And so if you can't go to the place to go, where do you go? So there is no harmonization of particularly issues relating to forum necessitatis. So just to give you another example, an old example really, where it would have evoked similar issues. If you recall, South Africa had a silicosis case where ex-miners took Anglo-America, firstly to the UK in 2013. The UK court dismissed this case on the basis that there is another forum that can hear the case. So basically, essentially using forum non-conveners and evoking this issue. So in that case, the parent company failed to advise the mine on prevention of dust exposure and silicosis. And I mean, what we have here is that the interest from the victim's perspective to take the case to the UK is that, one, you could end up with having higher damages because it was about, I think, 15 billion assets located within the parent company. And two, a speedier legal process. Which is usually the case, I guess, for many also global South and particularly African contexts, where the cases can either be compromised slower, but usually South Africa is one of the jurisdictions with the stronger court systems. So this case basically just shows how important forum shopping can be in the case of ensuring that victims are able to access justice. So I guess to just close, you have these two instruments, the CSDDD, and you have a legally binding instrument that Ariella will touch on. And because there are rumors now that when the EU eventually negotiates at the international level, it will use the CSDDD as a basis for negotiation. And I mean, when we engage with our governments, we should make sure, for those that do go to Geneva, that this doesn't happen at all. Because if this does happen, the CSDDD will effectively weaken the legally binding instrument, especially from a global South perspective. So then going back to the main question that I posed in the beginning, who should be regulating global value chains? It is absolutely at the multilateral level where global South states, including global North states, have an equal stake in the process. And it is in this process that an instrument that regulates at the international level should be monitoring global value chains. So to ensure that both instruments are mutually reinforcing and complementary. So yeah, that's all from my side.
Thank you so much, Siko, for that presentation. And the last speaker for the night will be Ariella, who will build on Siko's comments by looking at the gaps in accountability that have been left by due diligence measures and how this justifies movement for a business and human rights treaty. Ariella Sher is an attorney and head of business and human rights program at CALS. She represents vulnerable and marginalized actors in their fight against corporate impunity and works to capacitate state regulators, workers, and civil society actors to better hold corporations to account for their conduct. She holds a Bachelor of Social Sciences and an LLB degree from the University of Cape Town and a master's degree in international human rights law from the University of Oxford. Ariella has previously worked as a legal researcher at South Africa's Appellate Court and as an attorney specializing in employment law and labor policy. Over to you, Ariella.
Thanks, Anda. I just want to confirm that you can hear me. Yes. Okay, great. Again, thank you so much for having us. I think this has been really interesting so far, so I'm not going to speak for too long, but I just want to build on some of what the other panelists have said, and particularly what Siko has said, and build the critique of the current, at least, CSDDD. So the first thing to note is, as Inga said right at the beginning, this is very much the current version of the CSDDD is very much a compromise document. Because of the political nature of the negotiations. So my understanding is that the current compromise version covers 0.05% of all companies within the EU. So if we can think about how extensive that might be, it's not that impressive. So even though the EU is a big space and those companies, that might be a lot of companies, in the broader context of things, we can do a lot better. And again, to highlight, as Siko said, that human rights due diligence is a form of self-regulation. And the argument that we've been making and that many in the Global South have been making is that self-regulation is it's insufficient for the level of protection of human rights that we need, power that particularly transnational corporations currently hold within our jurisdictions, and a recognition of that imbalance between their power and the relative power, particularly of our states. So self-regulation, it's not mutually exclusive to a binding treaty, but it's insufficient, and we would promote the binding treaty. So just a quick background into the binding treaty. We're now in the 10th year of the process at the UN. The process was initiated through a resolution from South Africa and Ecuador in 2014. An open-ended working group was then established, and we've been negotiating ever since then. So October will be the 10th year of negotiations. And as Siko alluded to, the EU has arrived consistently without a mandate. They say they don't have a mandate to negotiate. And the EU is incredibly important for political buy-in in a space like that. And we're anticipating that this year, now that there is so much movement towards the CSDDD, that they will come and say, we're happy with self-regulation, we're happy with due diligence processes, we don't need a binding treaty. And as I've said, we believe very strongly that that's insufficient. A few reasons for that and for why the binding nature of the treaty would be much more preferable is firstly that because exactly as is indicated by the CSDDD, due diligence mechanisms amount to, at the moment, regionalization and differentiation. And in the context of transnational corporations that are operating across the world and through their supply chains that specifically are operating largely in the Global South or aspects of those supply chains, that level of differentiation and regionalization is just insufficient to protect rights in the way that we need to. We need an international binding standard. That is what will, as Siko was alluding to, that is what will address the issues and hopefully go some way to promoting human rights. The differentiation or the regionalization promotes a race to the bottom, not a race to the top. And that again underscores why we need a binding international standard that everyone has to comply to it. We have to set a floor. And then as Inga was saying, like in the context of the EU, the idea is that the CSDDD sets a floor and then states can build on that floor as to offer as much protection as they want. What the binding treaty envisions is establishing that floor at a consistent international level. So the argument at the moment, because of the political realities, is that regional implementation or adoption of due diligence measures just hinders the work towards passing the binding international measure. The issues with self-regulation as distinct from binding, the binding nature of an anticipated hoped-for treaty is largely that the establishment and the implementation of the prevention plans in terms of due diligence measures is entirely at the company's discretion. There's no requirement of transparency, of access to information. This gives rise to the issues about the burden of proof. You know, if I'm going to allege that a company has violated my rights, but that company, which transnational corporations are notorious for holding their information very close to them, I am not going to be able to prove that violation if the burden of proof rests on me. So all of this works together this works against the protection of rights and access to remedy for victims of corporate human rights violations. And as I was saying, that this ties into the lack of any sort of requirement for access to information, for transparency, particularly in the CSDDD directive as it currently stands. So there is no ability, or at very least, the CSDDD doesn't recognize any ability for the victims to be able to access the information necessary to prove the violations and therefore to establish some form of liability. I have one more point, which is, I can't find it now. I'm so sorry about that. But essentially that this is what we're gearing up to in the movement towards a binding treaty, and what we're anticipating at the negotiations in October this year is that it's now going to be a fight, essentially trying to pitch due diligence as mutually exclusive to binding instrument. Due diligence is really, really important. So it's not, we're not saying that it's not important, that it's a waste of everyone's time. It can go a very, very long way to offering recognition of human rights obligations and opportunities for discussion that might lead to protection. The argument is that it is necessary but not sufficient, and that the binding instrument is what provides the floor, as I said, that will allow protection of human rights and access to remedy for victims of corporate human rights at a consistent level across the world. And then we can go as wild as we want with due diligence once that floor is established. So that was just what I wanted to add on to the discussion, but of course we can have questions and discuss it further.
Thank you so much, Ariella, and thank you to all the wonderful panelists for such an enriching and such an important conversation to have. At this moment, I will open the floor to the audience for questions, for comments, and I would really like to ask that you please, in the interest of time, keep it in under 2 minutes at the very least. So, please do ask any questions you might have. And please specify which speaker you are directing your question to. Thank you.
Good evening. Is there legislation in South Africa that compels due diligence on the part of corporates? Anyone can answer.
We'll take 3. Please go.
Okay, thank you to the speakers. It's actually open to any 4 of you. So my question is with regards to, we now have the framework in the EU, or it's going to come in. I'm more interested in whether there's a link with, maybe you've explained it, go through it a little bit more with civil liability. So in my mind, I'm thinking of your Chandlers. We've got lots of these cases that have been running through in the EU, UK, Canada, and so forth. So does the framework make it easier for those cases in terms of litigating, burden of proof, theories of liability, or, it actually makes it worse? Just walk me through, someone trying to prove like duty of care, for example, and maybe they get all the information from the due diligence frameworks, and then they take that and intersect it or link it with their case. Maybe it's a class action, you've got 5,000 miners trying to sue in the UK. Does it help or does it make it worse? I think that's where I am in terms of my thinking.
Thank you. Thank you very much for the wonderful presentations. Mine is also to either one of you four. I'm wondering, we are talking about the EU due diligence standards. I'm wondering if there's conversations in the African continent, both for due diligence and for the binding treaty. What is Africa's appetite for the binding treaty and perhaps even for the due diligence sort of instrument? Thanks.
Thank you. We will just take that 3 for now. I don't know if any of the speakers would like to take any of the questions.
I
Please
can
go
take
again.
the first one. I think it's an easy one and it's a no. But as Wandisile said, because we have a justiciable Bill of Rights in our constitution, and that informs all of the pieces of legislation that we have in the respective areas, you might have different pieces of legislation requiring different forms of due diligence in their respective practice areas or fields, but there's no composite human rights due diligence framework yet.
Maybe to add on that point, is what then any due diligence tool or legislation would be seeking to do, at least in the South African context. I accept we're talking about multi or transnational companies operating in different jurisdictions. In the South African context, which is present in many other jurisdictions, what a due diligence legislation would seek to do, it's already there. It's really about understanding your environmental impacts. We have all sorts of legislation in South Africa and across African continent that if you're doing an infrastructure project or doing any other development, got to understand the impacts of the activity on people, on the environment, introduce mitigation measures. So you've got that sort of tool. Similarly, on human rights, I cannot see any business in South Africa, in Africa, thriving, employing child labor, because there is laws against it. So which I was persuaded by Arela that we accept that these instruments are setting the floor and can do more. And maybe in this context, they are collecting instruments into one comprehensive body of law. Yes, but maybe to touch, which fits into the point you are making, I haven't really done an impact assessment of the CSDDD on whether is it improving or worsening, what is the civil liability considerations and all of that. But similar to all these instruments for me is they unfortunately wouldn't do much because let's take, for example, the example you're giving on duty of care. You will remember all the cases around Shell, director liabilities, and the one recently launched a day or two ago, Total Energies. That is, they are all about trying to define. It is not, I can't see CSD resolving that problem alone. The burden of proof is an age-old legal trick that you will always overcome as instruments of collecting evidence become better. And it becomes very difficult in an environmental impact context. Like Paula was now mentioning, that you've got to always consider the impact at a project level, at a country level, at a company level. And in most instances, the human rights abuses or environmental breaches tend to have a wider impact than one person. So that is going to always to be an inherent difficulty. But I think with with us becoming better at document or evidence collection, those difficulties will become less of a problem. I'm not thinking that it would be an instrument per se solution, but as I say, I haven't done that impact assessment of how it does, but just thinking it out loud, that would be my initial take on the point. Thank you.
So just to address the question also on liability, my understanding at the moment is that the current CSDDD, it ties liability, the duty that it imposes on the companies is a duty of due diligence, which is very different from a duty to respect and protect human rights. So to the extent that the company can demonstrate that it's performed its due diligence obligation adequately, there is no liability other than that. So that's, I hope that makes sense.
Can't prove that it's done the due diligence. Maybe can that help the claimant?
One would hope so, but again, the burden of proof then will rest on the claimants, and it's incredibly hard to prove that when there is also no requirement of transparency or access to information. So how do I demonstrate that a transnational corporation that's showing me a prevention plan but has still violated my rights has violated the contents of their prevention plan, when the only people who really have access to that prevention plan or who are required to have access are the transnational corporation and any auditors that it has hired themselves. So there is no general duty of transparency or access to information. The other thing that's problematic in terms of liability is that the current CSDDD has no mention of criminal liability at all, which we would consider as being very important, both criminal liability of the juristic person of the corporation, but also of natural persons such as directors, but also individual people connected to the company. So there's a complete absence of that. That is not mentioned. So that's the answer, well, my answer on liability. I don't know if anyone wants to expand.
Well, I'm not a lawyer, so I'll focus on what I know. Just on the question about African appetite on business and human rights. I mean, you raised quite a valid point, because this has always been the criticism of global North states, of global South states in the legally binding instrument process in Geneva. Especially, first of all, when it starts with the implementation of the UNGPs and including the adoption of national action plans, very few African countries have actually taken up the process of implementing national action plans. So, for example, Ghana just started to implement national action plans. I think Mozambique is considering to implement national action plans. And so they have always felt like, the global North states have always felt like, but why are you so invested in a process without even actually implementing what we all agreed on in the last time, you know? So they feel like there's a big gap between the UNGPs all the way to a legally binding instrument. So, however, we have seen developments in the continent, including, for example, there's a yearly business and human rights forum that's usually held. Last time it was held in Accra, and also we also have seen the new business and human rights resolution as well that has just been established. So it seems there is a bit of hope. And also, I mean, even generally at the international level, we are seeing more and more relevant African states coming to the table, relevant in the sense that they are part of global value chains. Nigeria came to the table for the first time. And I remember when we engaging with the South African mission in Geneva, they were like, well, but where's Nigeria actually in the process? So even from the African group itself, what you saw last year is that it was united, for example, on issues of scope. So that was the only region that was actually united on scope. Scope was quite a big thing during the process. So we are seeing the African governments coming to the table, becoming stronger and stronger, I think, every year when it relates to this topic. And I guess that's also something you touched on, Wandisile, is that there's a changing geopolitical context in which African countries are becoming relevant players. So if this is exactly the right time to implement something like this from an African perspective.
One of that is that the UN panel appointed by the UN Secretary General, chaired by South Africa, which is going to report in the assembly in September. One would hope that because it's South Africa and EU, European Commission, then one would expect that South Africa is going to lead the African voice, or at least solicit the African voice in presenting its recommendations.
Inga?
Yes, I would like to add something to the question of civil liability, if I may.
Please do.
Yeah, I think the biggest progress that we have in terms of civil liability with the CS3D is that it establishes corporate responsibility of EU companies operating abroad. So before, that was very much dependent on the national laws in which these companies were operating. I give you an example. I think it was about 10 years ago. There was a fire in a factory in Bangladesh, which actually supplied German textile companies. And the case was brought before a German court, but it was dismissed because it should have been submitted to the National Court of Bangladesh, and it could not have been negotiated German court. So this is the thing where the CS3D actually makes a difference. And another difference is also that complaints can now be brought forward by NGOs and CSOs, also on behalf of affected persons or communities. That is supposedly making it easier for affected persons and communities to actually bring forward a complaint. But I think there's several challenges, and some of the other panelists have already alluded to this. I think the biggest challenge is establishing a causal link between a damage that has occurred and whether a specific company has caused this damage. And what is especially difficult is also the time frame, because the complaint has to be brought forward within a time frame of 5 years. Now, this might work for some damages, but for other damages that are more long-term, especially in the area of environmental damages that can only be detected after a longer period of time, this is not covered. And again, with the burden of proof, a lot of these persons or communities that have been victim to company. Oh, sorry. What the fuck?
Inga, are you still? Are you
No.
still addressing your question? Are you done?
I'm sorry. My laptop just totally went black.
It's okay. In the interests of time, we will just take 2 more questions, and I already identified my speakers because they had their hands up already. The lady right in front of you. No, ma'am. Sorry. The lady right there, she had her hand up first in the first round of questions.
Thank you very much. And thank you so much to the speakers. I really enjoyed the presentation. I learned so much. I was particularly interested in what you were all saying about civil liability. And I know we've spoken about that a lot already. But I wanted to ask specifically about civil liability in the context of climate change, which is an area that I do a bit of work on. We've obviously discussed this quite a bit already, but I was wondering whether what you will think about the potential of the CSDDD in the context of trying to hold carbon majors, so big international companies that are responsible for climate change, holding those companies liable for climate change damage in other countries. We're seeing, I'm sure you're all aware, we're seeing a lot of those sort of cases coming up at the moment.
Please keep it brief.
I'm sorry. Yes.
Thank you.
That's essentially what I would like to know. I'd be interested particularly to know what Inga thinks about it, because she is obviously steeped in the European understanding of the CSDDD as compared to what Siku and Ariella in particular think about it, because you were very critical of the CSDDD. But of course, I'm sure all of you have interesting things to say about it. Thank you very much.
Thank you.
Thank you all for the lovely presentation. So my question is, what impact will the due diligence have on the global economy?
So any of you can speak. I think Inga, the first question is directed to you. While we're waiting for her, can we please discuss how due diligence, what impact will it have in the global political economy?
I mean, I'll go for the climate question actually, because my name was mentioned. Funny enough is that the CSDDD actually is actually not too bad when it comes to climate change related liability. It does have provisions for environmental impacts, which is even actually in that sense going even further than what the current legally binding instrument is doing actually. And so that's why we're saying the instrument is not necessarily, it's not irrelevant, it's necessary. But it's just, as Ariela said, the floor, you know, it needs to be built on. But on this particular thing, it actually goes even ahead of the binding treaty on business and human rights. So in that sense, it is quite ahead of its time. Yeah.
If I can just add to that, I think that the evolution of law through the courts is outpacing the impact that CSDDD would have, especially through all the senior counsel legal opinions that are being issued, particularly around climate change. I think we've got 5 already across the country, across the globe. And a matter of a few weeks ago, the first senior counsel opinion on nature-based solutions being linked to duties of directors' duties of care was issued. And so those legal opinions are informing court precedent faster than ever. And that will, I think, have a bigger impact in the shorter term.
I guess from my side, I would distinguish between environmental impacts and specific environmental degradation and causing the climate crisis more generally. I think that in any event, in any case, in relation to any transnational corporation, we're going to have an issue proving the causal connection between the climate crisis and that particular transnational corporation, and how much more so using a due diligence measure that doesn't obligate them not to cause climate crisis, it obliges them to do their due diligence. So I think that you would come to a huge issue with the causal connection and with any proof there. So I would suggest it's likely to be insufficient for that. But in any event, so is the binding treaty. We also need much more significant focused climate crisis prevention mechanisms.
Thank you. Any one of you brave enough to predict
Yes.
the future? That's one person.
Impact of due diligence on the economy, I think it can only be good if we understand what it seeks to do, and especially in the context currently crafted that it's self-regulatory in the main, because what due diligence should be doing, where it would become too difficult, is if it was imposed with all sorts of onerous obligations or creating significant burdensome compliant obligations. Here it is, that's what is posing a challenge to the company that you do good and demonstrate the good you're doing. How you do it is up to you, as long as what you do is ensuring human rights protection and environmental protection whilst doing your business. From that perspective, I think it should be good. Yeah.
Thank you so much to our panelists for the night. Please give them a warm round of applause. Thank you. And thank you to you, the audience, for gracing us with your presence on a Wednesday evening. Thank you for taking the time out. And I would also like to thank Bowmans for hosting us this evening, for partnering with CALS in this seminar series, and just, you know, allowing us to have our event in such a beautiful space and auditorium. Thank you so much. I would like to call David to come up to assist me with gifting our panelists, but I would like to also just remind you that we have some snacks and some food outside. And yeah, thank you so much. Thank you for coming. And please, I hope you enjoyed our conversation tonight, and that, you know, you will grace us with your presence again when we host our next seminar series, which will be later in the year, around September, October there, but we will share the details. Please be on the lookout. And have a wonderful evening. Thank you so much.